Welcome back. I want to pick up where we left off, which is now starting to think about tenant defenses in these cases. As we noticed on the defects that we saw before are enough to get the case dismissed, the landlord is just going to start up again. And so one question you may have is it worth that if the landlord can just start it up again? And obviously every case has to be decided on its own merits, but there are two reasons why it probably is. One of them is time is important, and if you're able to get the case knocked out and the landlord has to start up again, it's going to be another month or more before the landlord is back there, and that month is valuable to the tenant. And then the second thing is that month is then an opportunity to actually figure out if there's some substantive defenses to the tenant. The tenant might, in fact, have a pretty good case. You won't know it very well, and you won't be prepared if you pick it up on the court date. But if you're able to get it dismissed, then there's an opportunity to start digging in to the merits of the case, and there may be some good defenses. So in the next section of the training, we're going to talk about tenant substantive defenses. So one kind of defense is what we've talked about, which is a challenge to the plaintiff's prima facie case. And then the other kind is an affirmative defense, right? Affirmative defenses are yes, but defenses. Yes, you made out your prima facie case, but I've got something too. And tenants in summary process cases can raise both affirmative defenses and counterclaims. And so we're going to talk a bit now about how that gets done and the kinds of defenses and counterclaims tenants can bring. The really core and most important place for tenant defenses and counterclaims is Chapter 239, Section 8A. If you haven't taken a look at it, you should take a look, and you'll see it looks almost like a set of Treasury Department regulations. It's very long and very intricate, but it's quite important and quite powerful. In court, you'll hear it referred to just as 8A, or you'll hear it sometimes called the Rent Withholding Law. And 8A allows a tenant to use claims against the landlord as an affirmative defense to possession. And it can play out in two ways. One of them is the tenant's counterclaims may completely offset a rent claim of the landlord. And the other way is that even if the tenant comes out behind after the money has been accounted for, the statute gives the tenant 7 days to pay up. So suppose the judge says, okay, tenant, you owe the landlord $2,000, landlord owes you $2,500. The tenant keeps possession and gets $500. The judge says, tenant, you owe the landlord $2,000, but the landlord only owes you $1,200. The tenant still gets to pay if the tenant pays the balance of $800 and it's a 7-day statutory time period to cure. So this is a very powerful statute. 8A is only available in a non-payment case or a no-fault case in a residential tenancy. So it's not available in commercial cases, it's not available in post-foreclosure cases, and it's not available in fault cases. But it's available in non-payment and also in no-fault cases. Milton, next slide. So a really common fact pattern is non-payment, just like the example we looked at before, and really common for the tenant to say, but there were bad conditions in the apartment. And those can be a basis for counterclaims and defenses under 239(8A). The statute requires that the landlord knew about the problems before the tenant was in arrears, and that the tenant is not responsible for the problems. And so landlord's knowledge is going to be critical, but there's no particular way for the tenant to prove it. It can be proved based on inspection reports. It could be proved based on text messages to the landlord. It could be proved based just on the tenant's statement, I told the landlord. The 239-8A, though, does provide some statutory bases. Under the statute, an inspection report from the Board of Health creates a presumption that the landlord knew about the problems and is prima facie evidence that the conditions existed. So while there's no requirement of an inspection report, having an inspection report is really powerful. Milton, you want to put up the...
We're having a Skype issue, but it should be good.
Okay. So this is an example of an inspection report. And this is in the handouts that we've sent to you. The inspector comes out, will typically have a handwritten notice like this. And then a couple things to notice on it. So the property and the conditions and the provisions of the code.
How do you get an inspection report? If you're in Boston, just call up the city's Department of Inspectional Services?
That's right. So in Boston, it's the Inspectional Services Department. Outside of Boston, it's the Board of Health. And they keep the records, and they're happy to issue them to you and certify them for you.
Cool, I think we're live.
And then a particularly important thing is down here, it says this inspection report was certified under the pains and penalties of perjury. And 239-8A makes that certification by the inspector prima facie evidence. So it's really important to have that on there. After the initial inspection report, there usually is a repair order from Inspectional Services, which looks more like this. And Inspectional Services will then serve this on the landlord. And it tells the landlord what the problems are, what has to be done. It should show the provisions of the sanitary code. That's what these numbers are down over here, 500, 351, and so forth, showing which provisions of the sanitary code are at issue there. So the 239-8A keys right into the common law warranty of habitability. Anybody heard that term? Great. So you know from contract law that there are various warranties. And there's a warranty in residential tenancy that the place will be up to the sanitary code at the inception of the tenancy and will stay up to the sanitary code during the tenancy. And if it does not, then the tenant is entitled to warranty damages, the difference between what the premises would be worth if it was up to code and what it's actually worth in its defective condition. So defective conditions could be things like lack of hot water, broken windows, leaky roof, pest infestation. The landlord, as we said, is only liable from the point that the landlord knows or should know about the problem. And the rent abatement is calculated by the difference between what it would be worth up to code, what it's worth in its defective condition.
Just a quick question. Do
Please.
clients usually come in with how much it costs to repair that or the damage? Do the clients come to the clinic with that?
So it's not actually, the question is, do they come in with evidence of the repair costs? And it's not actually a measure of repair costs. It's a measure of the difference between what it would be worth up to code and what it's worth in its defective condition. So if the roof leaks, it might cost the landlord $10,000 to fix the roof, but the measure of damages for the tenant is going to be how much less is this apartment worth with leaks coming through the living room ceiling. Maybe the leaks in the ceiling are not too bad and it's only a small diminution in value even though it's going to cost the landlord a lot to repair. Or it could be a cheap repair to make, but really serious consequences for the tenant.
I was just asking, does the client walk in with that figure?
So clients, I think, never walk in with that kind of information. They'll be able to tell you what the rent is, and then you'll have to try and figure out a reasonable estimate for the abatement value, the diminution in value, based on the conditions. One way to do that is on a percentage basis, to say, well, the leaks in the ceiling make it worth less 5% a month, and the bad windows make it 10% or less a month. And having no heat in the middle of winter makes it essentially worthless, 100% abatement. But there are no real formulas for these things. You have to sort of figure them out.
That day.
Well, in thinking about it, I mean, eventually, if you don't settle, eventually that'll be a decision that gets made by the judge or the jury. When you are trying to settle a case, you've got to make your best estimate, and the other side will make their best estimate, and if you're close, you may settle, and if you're far apart, then you may need a trial. Paul, and then we'll move on.
So sometimes clients come in before the whole eviction process has started, and they talk about their landlords that have been doing certain bad things. Is it recommended to recommend them to go get ISD inspector as soon as possible?
Right. So the question is whether it's recommended to get an ISD inspection as soon as possible, and the answer is yes. So if you're talking to somebody in advance who says, you know, I've got all these problems, I would certainly recommend, let's get an inspection in right away. Both we want confirmation of it, that's going to be good evidence at trial. We want the landlord then being ordered to repair it. So definitely get an inspection as soon as possible when there are bad conditions at issue. I want to mention a particular species of problem, and that's quiet enjoyment. You may remember from property law, quiet enjoyment is a term in property law meaning essentially good title. And it's used here to mean whether the tenant is getting the essence of the tenancy. So the landlord could interfere with the tenant's quiet enjoyment by locking the tenant out. Obviously, that goes to the essence of the tenancy, but also by other kinds of serious problems like no heat, no hot water, or just really bad sanitary code violations. What makes this statute a little bit different from breach of warranty is that the statute, it's a statutory claim. It provides for a minimum of 3 months' rent as damages, and it provides for attorney's fees. And it specifically provides that the rent and attorney's fees can be used as offsets to rent that the tenant owes.
Is that part of 8A, or is that a...
So that's not, it's not an 8A, it's in a different statute. It's Chapter 186, Section 14.
So another claim that comes up pretty often is a violation of the security deposit law. Everyone knows what a security deposit is. I think I don't need to go over that. But the security deposit law is also very long and very complicated. And so because of this, there's a lot of ways that the landlord can screw this up. And so if a tenant comes to you and says that they gave the landlord a security deposit, you're going to need to do some digging there because there's likely a claim there. Because it's really hard for a landlord to hit every single point of the security deposit law. So the basics of the security deposit are that it cannot be more than 1 month's rent. It's paid at move-in. The landlord has to give a receipt that they received the security deposit. The deposit has to be placed in a separate interest-bearing account. At the end of each year, the landlord has to give us the statement of the interest earned, and then the tenant can either take that interest as a payment, or they can apply that to future rent. The security deposit has to actually be returned to the tenant after the tenant vacates, and it has to be done within 30 days. Now, the landlord is allowed, because it's a security deposit, to take certain deductions from it, but those deductions are prescribed by law, okay? So they can only be unpaid rent at the time the tenant leaves, an increase in real estate taxes if the lease says that that's part of it, and cost of repair to repair the damage that's caused by the tenant. Okay, and so that makes the importance of move-in condition statements really, really important. So this is a typical one that you might find. This one's available online, and so what happens is when a tenant moves in, the tenant and the landlord go through the property and they list all the defects that might be there. When the tenant moves out, they're not going to be responsible for anything that's written on this. So there shouldn't be any fight about that. It's going to be about the things that aren't listed on this. And the tenant is not going to be responsible for normal wear and tear. But when the tenant does move out and the landlord does have stuff to repair, they're going to need to give the tenant a list that looks very much like this. Again, this one's found online. That lists the damages, the cost of repair, and this is sworn under the pains and penalties of perjury. So again, it's really important to have that condition statement up front, so you know what the tenant is responsible for and what the tenant is not responsible for. So the violations of the security deposit law, it's going to be strict liability. So the landlord's knowledge of the law or negligence is not an excuse. And there are going to be two types of relief depending on the violation, right? It's either going to be return of the deposit and the interest accrued, or it's going to be triple damages. So triple damages can be awarded for failure to return the deposit or balance due within 30 days after vacating, failure to place the deposit in a separate interest-bearing account, or failure to transfer the deposit to a new owner. All other violations, so again, like I said, the security deposit law is really long and really complicated. Other violations can be, a landlord is supposed to keep records of their security deposit for 2 years, right? If they don't do that, it's a violation of the law, but that one's not worth triple damages, right? So that's one of the instances where the violation is just going to be the return of the security deposit that the tenant gave and whatever interest is accrued to that point. The landlord can avoid triple damages if the deposit is returned immediately upon demand. And also, new owners are liable for the deposit even if the old owner fails to inform the new owner that it received a deposit from the tenant. And again, there are attorney's fees and costs associated with pursuing this claim. Yes?
And does it matter if the landlord is a single, only owns one place, or do they have to be a commercial?
What a great question. Okay, so the question is like, which landlords are actually liable, right? So all landlords are liable for this, so for the security deposit. There are going to be some claims that we get to later where depending on if the landlord owns very few units or they own a lot of units where they might be exempt from that claim. But anyone that takes a security deposit is going to be liable for any sort of violation of the law. Oh, let's see. Another claim that might come up is the last month's rent. So a lot of times, when people move in to a new place, they pay first month's, last month's security deposit. The last month's rent also has to be handled a certain way. In a lot of ways, it's like the security deposit too. Not more than 1 month, paid at move-in. The landlord has to get a receipt, and it has to be placed in an interest-bearing account. At the end of the year, the tenant has to receive a statement, get the interest. The tenant can either use that interest or use it for future rent. The damages here, though, are triple the amount of interest due if not paid within 30 days of vacating. So there's no triple damages on the value of the last month's rent itself, but on the interest that's accrued. And this is also worth attorney's fees and costs. And there's a little snapshot right here of what the landlord has to do and what the tenant is owed for security deposit and also the last month's rent. So that's a handy little guide. Are there any questions? Yes.
Is that an affirmative defense to eviction, or is that just a counterclaim?
So again, it can be a claim, right? It can be a claim for money. But remember what we talked about first, which was 239(8)(a). That's kind of your gateway into using any claim as a defense to possession, right? So the security deposit itself isn't a defense. But if you allege 8A, 8A allows any claim that arises out of the tenancy to possibly be used as a defense. Any other questions? Okay. So another claim is going to be unfair and deceptive practices under General Laws, Chapter 93A, and we shorthand that just to 93A. So 93A is a general consumer protection law, and it sees tenants as consumers of a commercial service or good and landlords as a provider of a commercial service or good. So that's how tenants are protected under this general consumer statute. So damages are going to attach here when the landlord uses or threatens to use unfair or deceptive practices, right, that result in a cognizable injury. And the terms unfair and deceptive are really broadly construed. So some acts or omissions are going to be per se violations according to statute or regulation. Those include failure to correct the sanitary code violations in a reasonable time after notice, willful violations of quiet enjoyment. There are certain things like that which, if the landlord has done, we know are going to be a 93A violation. But other acts that the landlord does or omissions are evaluated under standards of oppressive or otherwise unconscionable in any respect, or they're going to see if the practice can be reasonably found to have caused the tenant to act differently than they otherwise would have, right? And so the idea here is that you can't list every unfair thing or deceptive thing that a landlord could possibly do. So whatever the landlord has done that we think might be unfair are going to be judged under these standards. Examples of those things can be sending papers that look like official court papers to try to fool the tenant, using unlawful lease terms, charging fees that they're not allowed to charge at the beginning of the tenancy, failure to give tenant a copy of the signed lease, things like that. So whatever kind of here feels intuitively unfair, when you hear a landlord has done something, you can certainly allege in good faith that it is going to be an unfair or deceptive practice. So if you hear a story from a tenant that sounds like they've gotten a really raw deal somehow, we can definitely say that it's a 93A violation. We can absolutely do that in good faith. Yes?
How often can breach of implied warranty overlap with unfair practices?
So it can always overlap. Yeah. So there's going to be a lot of overlap between things like breach of warranty of habitability, interference with quiet enjoyment, and 93A. A lot of times, those claims arise out of the same facts. And it's just really going to be a matter down the line of how damages are going to be awarded. But the same set of facts can give rise to all of those claims.
So like consistent failure to address like vermin.
Yeah, right. So that's going to be a breach of warranty of habitability, right? That's also going to be quiet enjoyment because the landlord consistently does not fix anything, and that's also going to be unfair under 93A. Okay. So in terms of damages, there has to be an actual injury, or in the housing court, it could be an acutal injury. It's the same thing. The injury is also defined very broadly, right? It can be monetary damage, but doesn't always have to be, right? So it can be the tenant giving up a right, because of something the landlord's done. They lose work hours, emotional distress, certainly can be an injury. And the damages are going to be $25 statutory minimum or actual loss, whichever is more. Okay. 93A also allows for double or triple damages for knowing or willful violations. If the landlord knowingly or willfully commits an unfair act, knowing that it's an unfair act, or the landlord fails to respond to a request for relief with reason to know the practice was a violation of 93A. And so a little bit of background here. We use 93A often as a counterclaim, right? Because we're helping out tenants who are being evicted. So they're the defendants. A tenant can also allege 93A or start a 93A action affirmatively. But to do that, they actually have to send a 30-day demand letter first. When we allege 93A as a counterclaim, we don't need to do that. Yes?
How do you know whether double or triple attaches?
So again, it's right here. Oh, whether it's double or triple?
Yeah.
Well, I mean, we would ask for triple, and then
Just judge's
then
discretion.
yeah, it'll be up to the judge to decide whether it's double or triple. Yes, we would ask for triple. Okay. So in 93A, the tenant can also request injunctive relief, right? So in the same claim, if there's the leaky roof, right, damages might attach, but part of the 93 request for relief would be also fix the roof. And again, no 30-day demand letter is required if it's asserted as a counterclaim. And here is one of the things that Kathy was talking about. Not every landlord actually is going to be subject to 93A. So public housing authorities and owners of 2 or 3 unit owner-occupied buildings are exempt because these are entities that the legislature has considered are not in the stream of commerce, right? So they're not providing good or service as a commercial practice. And so this Consumer Protection Act won't apply to them. 93A, though, also comes with attorney's fees and costs. Yeah?
So if you have different SPEs that own several 2 or 3 unit townhomes, but they're all under one umbrella ownership, are you a commercial landlord?
Sorry?
So I mean, like if I have several 3-unit,
Oh, yeah, you're a commercial landlord. For purposes of
okay.
93A, yeah, it has to be owner occupied. They have to be living in there. Okay.
So in response to the question Paul asked, I want to pick up on that, which is that 93A, security deposit, breach of warranty of habitability, breach of client enjoyment, those are claims. They are not themselves normally defenses to possession, but you can use them as the predicate to a defense under 239(8)(a), the statute we talked about before, which says you can use claims against the landlord as a defense to possession for non-payment or no-fault evictions from residential premises. The next defenses we're going to talk about are freestanding defenses. They don't depend on 8A, and they're available even in things like fault evictions. The first of those is retaliation. By statute, it is illegal for landlords to retaliate against tenants for exercising certain rights. If the tenant goes to inspectional services or writes a letter to the landlord complaining about conditions and the landlord responds by evicting the tenant, that's retaliation. It's illegal, it's a defense, and it also could be a counterclaim against the landlord. Things like this, as you would expect, are actually pretty hard to prove what's in the landlord's mind. And the legislature makes it easier by creating a presumption of retaliation. As a presumption of retaliation kicks in if the tenant exercises some protected right, and then within 6 months, the landlord takes some adverse action against the tenant, like sending a notice to quit, a summons complaint, raising the rent, some kind of adverse action within 6 months is presumed to be retaliation, and that puts the burden on the landlord to prove that it's not retaliation and that he would have taken the same steps at the same time and the same way, even if the tenant had not exercised these protected rights. Should note that there's an exception to the presumption, which is in a non-payment case, there's no presumption of retaliation on the counterclaim, but there still is on the defense. So action within 6 months creates the presumption for the defense, and it creates the presumption for the counterclaim unless it's a non-payment case. As we said, this is a freestanding defense, so even in a fault eviction, if it's retaliation and the landlord can't prove otherwise, the tenant has a defense to eviction. As a monetary claim, the tenant's entitled to her actual damages or a minimum of 1 to 3 months rent. It's the judge's discretion about whether it's 1, 2, or 3 months rent. But if it's actual damages, the tenant gets more, and there are also attorney's fees that come with those. Any questions about retaliation? Milton?
So another freestanding defense is going to be discrimination. So it's unlawful for a landlord to evict a tenant based on their membership in a protected class. We have included as sites here the major state anti-discrimination law and a major federal law in housing. So the state law is Chapter 151B, and the federal law is the Fair Housing Act. We included these because they're the big ones, but there are lots of other state and federal laws that protect tenants against discrimination. So be aware of that. We're not saying these are the only ones. But of course, the protected classes here, can be a whole host of things: race, religion, receipt of public benefit, familial status, lots of things, and also disability. And disability is one that we see, disability discrimination is one that we see actually a lot at the housing court. And this is when tenants are being evicted, but they have a recognized disability, and the reason that they're being evicted, some sort of bad conduct alleged by the landlord is somehow connected to the disability. Okay, if that's the case, there's a good defense to the eviction, and it's called reasonable accommodation. So reasonable accommodation is a defense that's available when a tenant has a recognized mental or physical disability, and the disability is related to the reason why the tenant could not meet the tenancy obligations, right? That's called the nexus between the disability and also the alleged bad behavior. So the reasonable accommodation itself is going to be a request to alter the rules or the policy or maybe even the physical structure in consideration of this disability so that the tenant can stay. So it applies to nearly all housing with very few exceptions. So be aware if you see a tenant with a disability that we're probably going to be alleging this and it's probably going to apply. And the reasonable accommodation, like I said, is going to be an alteration of the rules or policies, right? So on the request, there has to be some sort of plan, some sort of suggestion what those alterations are, right? And the outer limits for reasonable accommodation are just going to be that it's going to be, a request is going to be found reasonable unless it's an undue financial or administrative burden, or if it fundamentally alters the nature of the housing program. So when tenants come in and we ask for a reasonable accommodation, this is a basic reasonable accommodation request, right? It says who it is, that this person has a disability, and that we're asking for an alteration to the rules or procedures. So this is available on the cart, and it's something that we can use. It doesn't have to look like this, though. A lot of the larger housing providers have their own proprietary forms, and the tenants can use those as well. So important.
Question for Kathy?
So, can you give us an example of when, you said you have to show a nexus between the disability and the reason for the eviction?
Sure.
What's a good example?
So one good example could be if there is, a no pet policy at an apartment, right? But there is a blind tenant who has a seeing eye dog, right? And so there's a nexus between the disability and here, violation of the occupancy terms. But because there is that nexus and because the tenant has a recognized disability, then the reasonable accommodation, the requests you'd be making to alter the rules are, basically let this dog stay, don't kick me out for having a dog because I need it for my disability. So that's an example of a nexus. Okay, so importantly, reasonable accommodation can be requested even at trial, right? So oftentimes we'll be seeing clients at the court and they're going in front of the judge in just a few minutes, and maybe they haven't actually filled out an answer or anything else. They can still ask for reasonable accommodation in front of the judge at trial, and that's going to stop the proceedings, and the landlord's going to have to show that there's no reasonable accommodation that can be granted to let the tenant stay. Yes?
What type of proof or documentation is needed to show your disability?
So the question is what type of proof or documentation is needed to prove the disability. So there is going to, the landlord does have a right to ask for certain things, right? And so a medical provider is going to have to say that there is a disability and that this person needs a reasonable accommodation, but they're not required to say what the disability is.
So, and I would just add, I think it really depends on the context, and including what the accommodation is that you're seeking. So we're doing a case right now in which there was real violence in a public housing unit. Our argument is it's connected with the tenant's psychological impairments, and we're going to need, in that case, pretty good evidence to be able to show the nature of the tenant's psychological disability and why it resulted in this happening and why the accommodation is reasonable. On the other hand, we've had cases in which the accommodation we're seeking is pretty minimal and the accommodation is fairly obvious. Somebody who got way behind in her rent because she had some mental health issues and had difficulty managing her money, and essentially her statement and a statement from the people at the Tenancy Preservation Program at the court were sufficient to show that her disability was sufficient to justify that accommodation. So depends on the accommodation, depends on the problem. You have to figure out the context. One more?
This example makes me think of when is another tenant in the unit behaving in a way that interferes with my quiet enjoyment? And what can I do about that?
So this is a co-tenant or like a tenant down the hall?
Down the hall, drug activity in another department or something.
So that's a tricky one. I don't think that there's like a definite answer for that. You know, it's possible it could be a quiet enjoyment claim if you can say that, you know, the landlord is responsible somehow for making sure that this tenant also follows the rules of the building or whatever else so that they don't interfere with your quiet enjoyment. So that could be a claim against the landlord. You know, maybe it's possible to say that, you know, this is somehow, you know, a breach of the lease if you have a lease, and so you're gonna somehow nullify the lease and move out. I don't really.
Because I had a question where a person was getting a unit in a supposedly drug-free house, and he was recovering at it. He said there's drug activity going on in the other apartments that the landlord not doing anything about.
Right, so that part of it actually has an easy answer, which is that current drug use is not a disability. So the landlord has no obligation to accommodate somebody's current drug use. So if somebody's a current drug user and it's interfering with the tenant, then the tenant has a good claim there. The harder cases are where the problem is a disability, like some kind of mental illness that results in disruptive behavior. That would be a disability. That tenant is entitled to accommodation. And then it's a balance to figure out how much accommodation is reasonable, because we want to try and meet that person's rights to live in that apartment despite his or her mental illness, but also accommodate your rights to live in your apartment undisturbed, and that's going to require a balance. So we want to move now to the next breakout. And we're going to start where we picked off in the last one, so the same notice to quit, same summons and complaint, but now you're being asked to assist the tenant, and so we've given you a package marked Breakout 2. It has a brief fact pattern, and then it has a form, motion for late answer and late answer that we want you to fill out. So start with the stuff from last time, read the fact pattern, and then I'm going to give you till 10 of to finish filling out the proposed answer. Okay, even if you haven't finished, we want to reconvene here.
So we're just arbitrarily.
So we will go through the answer form together. So call out answers as we go along, and Milton has the other mic.
You know what? Actually, we'll distribute.
So as you recall, there's a deadline for filing an answer. So if you're seeing somebody at the housing court for the first time on their trial day, they're already past the answer date. So you're going to have to move for a late answer. So you can see that's number 1 in this form. We've built the motion for a late answer right into it. The next part of this is about defects in the landlord's case. So in the next block, 2 to 6, what do people check off? Go ahead. Okay, 2, 5, 3.
That's 6. Explain that
Uh-huh.
discrepancy in the dates.
Okay, good. So 2 is I never got a notice telling me to move before I got the summons, right? That's the timing issue we talked about before. 3, the landlord started this case before the notice to quit expired. In this case, same thing. Some cases it could be different. 4, did somebody say 4? Okay. And then 5, not everybody who should be on the eviction has been named in the notice or the complaint. So those are the defects we found before, and you can see where they go on this form. Okay. How about 7? Anybody check off 7? Okay. So if somebody checked off 7, that it's retaliation, tell us what you think. Milton, if you can bring the mic.
So we thought it was retaliatory because they complained to the ISD before they were evicted.
Okay, good. And that's going to create a presumption of retaliation. This is a non-payment case, so it's not a presumption on their counterclaim, but it is a presumption on their defense that the eviction is retaliatory. How about in 8 or 9, the eviction is discriminatory? Okay, no, we didn't have anything either. But remember, that could be where reasonable accommodation could come if you had it in a case. And 10 is this general catch-all that we always check off, what almost never works, which is just something about this eviction is just unfair. So use it, but don't put a lot of weight on it. (12, 13, 14) are really about post-foreclosure evictions or about something else that's really fundamental in it. How about going down to 15 through 18? The landlord claims I did something that I did not do. Any takers here?
Not a taking, but going back to number 10, you said always check off, it's unfair. It seems to 11 is related to that.
That's right.
You're gonna
You have to.
come up with some clause.
That's right. You're going to have to explain it. One case I can think of on this, it's just unfair to evict me, was a woman who had an adult son living with her. She had tried to get him on the lease. The landlord refused. They brought an eviction case saying you've got an adult son living there. It was true that she had an adult son, and they therefore could point to a violation of the lease. But the judge said it's not fair to evict her for this when she's been trying to put the son on, and the landlord refused. So that was a case where the judge said this eviction would just be unfair. So it is possible, so be creative, but in most cases, it's not going to go too far. So concentrate on the others. Okay, so nobody had anything saying I'm accused of something I didn't do. The next one is my landlord cannot evict me because I don't owe rent, offered the rent owed, or have claims against the landlord. So in 19 and 20, anybody have anything? Go ahead.
Yeah, 19 and...
Milton will give you the mic.
I had 19, like the top one, and then I checked, I have claims against the landlord
Good.
at the bottom. And 20, I had the top one checked, and I had the landlord has failed to give me enough heat or hot water. And I mean, I guess you could also check the first one, I mean, because they're the same. I mean, it's a bad condition not to have heat. So I mean.
So you got them all. Okay. What are other people?
Question about 19, the second sub-box. The second sub-box, I don't owe the amount the landlord says I owe. We were discussing whether or not you should check that off because you're going to be saying I shouldn't have to pay the full rent because there's no heat in the building.
You have thoughts on that, Milton?
I think it's written loosely enough that we could make that argument that yes, since I have claims against the landlord, it wasn't worth this amount of money, so that's not money that I owe the landlord.
Right.
Yeah.
There are separate boxes that are going to make that more explicitly, and this is primarily meant to cover situations where there's a real bona fide dispute. We helped somebody at the table a couple weeks ago where the landlord had illegally raised the rent from $1,100 to $1,500 or $1,600 and was evicting for non-payment of that difference. And that's one where the tenant could say, the landlord's asking for this rent, I don't owe it. Anything else on 19 or 20? Okay, and here's more of 20 up at the top. Anybody else have anything more on those 3 boxes up at the top?
We also checked the landlord knew about these problems before I was behind on my rent because they were there when I moved in. I told the landlord verbally, which I think should be orally. Anyway, and then someone else, because verbally means with words. Orally means you called them up. Anyway, and then last one about the ISD. I realize the timing's not perfect on the ISD, but I think it's worth checking off.
Everybody else See that? Other thoughts?
And then
Andre?
we thought we'd say that I am paying for electricity and then cross out the rest and say for space heaters.
Uh-huh. Okay, good thought. He was too fast for you. Other thoughts? Okay, how about 21 down through 25? Great.
There's one under 22 that the landlord entered my home without my permission or notice.
Uh-huh. You want to get the mic over, Milton?
So, okay.
22, box number 4 under that, the landlord came in, according to the wife, when they weren't there, and so maybe there's some damages associated with that.
Uh-huh. Right, and so that could be a breach of quiet enjoyment, which means if you make it out, the statutory damages of 3 months' rent. So even if there was not a lot of actual damage, there could be substantial statutory damages. Over here?
They also allow bad conditions to exist in my home. So I'm like warranty of habitability. I'm thinking if I don't have heat, like how?
That's right. So no heat would be a breach of quiet enjoyment, and bad conditions, if they are bad enough, can be a breach of quiet enjoyment. There are a lot of conditions that are big enough to be a breach of warranty, not big enough to be a breach of quiet enjoyment. Remember, quiet enjoyment gets you statutory damages of 3 months' rent. So I think about it, if it's a big enough deal that it seems like 3 months' rent is appropriate, then it's probably a breach of quiet enjoyment. Otherwise, it's probably only a breach of warranty. And then in the statutes, there's then a separate list of things that are per se breaches, like no heat, or locked me out, or illegally entered my apartment. Over here?
How about the security deposit stuff on 21? I mean, there's nothing in the facts to indicate that the landlord didn't comply with the security deposit law, but there's nothing to indicate that he did.
Yeah, I think my practice, because you have to do this stuff up front, this is really a sort of shoot first and talk later kind of thing. So my practice, if there's a security deposit, is to assume the worst on it, so that at least it has been pled, and then you see what you can find out about it. Because the alternative is to hold back, find out there's a good case, and then it's too late to get it in. So if the landlord took a security deposit and you don't have a reason to think that they did it right, I assume that they did it wrong.
But Dick, shouldn't you just amend later if you find out about a security deposit? Can't you amend your answer?
Well, in theory, you can. And in theory, the usual rules about amending pleadings is applicable in summary process. The problem is that because they're on a fast timeline, frequently the judges are not willing to allow for those kinds of things. Now, other people have experience on that here? And Milton, you should weigh in on that also.
I got nothing.
Okay.
So you would just check 21 generally, or would you specifically check this for us without knowing whether it's true or not?
Well, I mean, if the tenant says, I gave him a security deposit, I would ask, did the landlord give you notice about what bank it's in? Tenant says no, I would check off the box saying he didn't put it into the right kind of account. If the landlord then says, I did, and here's the proof, then the claim goes away. But I think, particularly given these expedited processes, you can plead in good faith based on what the tenant has told you if the tenant says, I gave a deposit and the landlord never notified me where it was. In an ideal world, we do some more development, but we don't have an ideal world. We're doing this on the fly.
Can you do some discovery, or what would you?
So if the tenant has gotten to us by the answer day, then there's a right to discovery, and we would certainly encourage the tenants to do that. And so if they said, I gave a deposit and the landlord didn't give me all these notices, I would do discovery about that, and then hopefully by the time the case gets to court, you'll have the information. If somebody's coming into you on the day of trial, you're already past the discovery deadline, the judges probably won't let you do late discovery, so you've got to manage with what you have. How about down in 26, 27? No, none of those on our case. In practice in the housing court, a high percentage of the folks that we see are in subsidized housing, but not the folks in our example. Okay, and then we're now down to a prayer for relief. And we made this easy for you because most of them are already checked off.
Does the volunteer law project go after attorney's fees?
So do you want to talk about that, Milton?
Sorry, what was the question?
This is attorney's fees.
Does he go after attorney's fees?
So what happens at the Lawyer of the Day clinic, right? Even though we allege a lot of claims, if we're actually in settlements, mediations that we're going to do later, it's just kind of the culture of the court that attorney's fees are not requested. If it also goes to a bench trial that day, they're also not asked for. But if you were to take a case full rep through VLP, yes, attorney's fees are then part of, typically settlement negotiations that are, more extended.
Right. So we would encourage you to seek out fees on fee claims, either for you to then be able to give them to the tenant directly or indirectly as part of a settlement, or for you to get the fees and then you can figure out what to do. And if you want to send some or all of them to us, we won't complain. So we've checked off, a bunch of the boxes are already checked off over here. Did anybody check off anything more?
How about under 41, asking the court to determine the appropriate amount of rent that should have been withheld?
Okay, you could do that. I think it's actually probably implicit in some of the others, but it would not hurt to say that in addition. And part of that process, as we talked about before, is to figure out who owes who more money, and if the tenant is the one who owes the landlord a balance after all of the accounting, then the judge is supposed to give the tenant 7 days to pay up that balance. And if the tenant pays in that time, then the tenant wins possession. Any questions about either the forms or about the kinds of defenses we've been talking about? The case, we're going to give you a break until just a couple of minutes, so just until 1:15. So come on back, and then we'll pick up with the next part, which is going to focus on mediation.